Now, I know you're anxious about the appeal process, and I would like to explain very briefly the appeal process for tenants and landlords under Texas law. In order to appeal, a tenant has to either post a bond in the amount the court sets, or a tenant has to file an affidavit of inability to pay an appeal bond. My experience is that almost 99% of the tenants cannot afford to pay an appeal bond. This means that in order to appeal, the tenant has to file an affidavit with the court within 5 days after the judgment, explaining to the court that he or she does not have the financial means to pay the appeal bond. Once the tenant files the affidavit of inability to pay an appeal bond, the landlord has the right under Texas law to file a contest. If the landlord files a contest, then the court actually has to schedule a hearing on the affidavit and determine whether the tenant does indeed have the financial means to pay the appeal bond in the amount set by the court. If a hearing is scheduled, don't panic. Simply attend the hearing, and if you have documentation about your income, take that with you. For example, if you're on Social Security disability benefits, try to take that information. If you're employed and have year-to-date earnings statements, take that information with you. But it is important to show up at the hearing on the contest if the landlord contests your affidavit. If there's no contest, or the judge hears the contest and rules in your favor, then the next step is for the court to send all of the papers up to the county court at law. The county court at law clerk then will, after receipt of the papers, send a written notice to you, the tenant, explaining that the papers have been received and that you have 20 days in which to pay a filing fee in the county court at law. If you fail to pay that filing fee or file another affidavit in the county court at law saying you do not have the financial means to pay the filing fee, then your appeal is dismissed. It's as if it never happened. So it is extremely important that once you receive that notice from the county clerk of a deadline of 20 days to pay the filing fee, that you either pay that filing fee in county court or file another affidavit, this time in county court, saying you do not have the means to pay the filing fee. In addition, if you do not file in the Justice Court a written answer, then you have 8 days from the date the appeal papers are received in the county court in which to file a written answer in county court. If you do not file the written answer in county court, then the landlord can go to the judge and take a default judgment against you. So the best practice is to file your written answer in the Justice Court at the same time that you file your affidavit of inability to pay an appeal bond. But if you haven't done that and you simply filed an affidavit of inability to pay an appeal bond, then when you receive the notice from the county clerk telling you that you have 20 days to pay a filing fee in county court, and the notice will also tell you that you have 8 days to file an answer, make sure you file that answer within the 8 days. If you fail to do so, the landlord can take a default judgment against you. Once you've paid the filing fee, filed an answer, then in county court, generally the process is that the case will not automatically be set. Either the landlord or you has to request a trial. Once a trial is requested, the court will schedule it for trial and you'll be notified of a trial date, and you can represent yourself again in county court if you cannot afford a lawyer and follow the same procedure you did with the justice of the peace. Take your witnesses and your documents. Keep in mind that an appeal to the county court at law is de novo. That is, the county court at law judge has to make a new decision. It's as if no decision has previously been made in the case, and the county court at law judge has to make her decision based on the evidence she hears at that hearing and not on anything that the justice of the peace may have heard or that the justice of the peace may have written down.